The Trump administration created a great deal of anxiety and chaos in the immigrant community last week when USCIS released a new policy memo requiring immigrants who are seeking a green card, which is also known as adjustment of status, to return to their home countries and apply and wait there for approval. Currently, immigrants are allowed to remain in the US while applying and waiting for their application to be approved. That is current policy, which is going to be changed by this memo. So let's begin today with Jeff Joseph, who will explain the memo, what's at stake broadly for immigrant communities, and the legality of the new policy, which, as I said, will likely be challenged in court. Welcome, Jeff.
Thank you, everyone. It's a pleasure to be here, and thank you all for taking the time to get out this story to your populations, to your media, and it's very important that the right messaging goes out around this because obviously there's a lot of panic around the memo. So I want to talk a little bit about the memo itself, kind of what the memo does, and then talk about the court challenges that will be filed very shortly on this. So what happened? So on May 21st, 2026, USCIS issued a memo that's called Adjustment of Status as a Matter of Discretion and Administrative Grace and, quote, an extraordinary relief that permits applicants to dispense with the ordinary consular visa process. And this was issued as a memo, a policy memo, and given to the field offices as instructions for how to adjudicate cases. So if you take just a step back for a moment, just the title of it frames adjustment of status as something that's extraordinary, that's something that's an exception, and it's something that's unusual, right? That it's something that's contrary to the normal course of action, which would be consular processing. And the question is that accurate? And the answer is absolutely not. Adjustment of status is both a matter of eligibility and discretion. It is true that the statute for adjustment of status says that the Attorney General may, in his or her discretion, adjust the status of an individual. So there is a discretionary component to adjustment of status, but there's a difference between an individualized exercise of discretion and a categorical blanket statement that adjustment of status is an extraordinary remedy and that discretion should only be exercised in extraordinary circumstances. The fact is, adjustment of status is not an extraordinary remedy. It's something provided specifically in the statute at Section 245 of the Immigration and Nationality Act. Congress has set it out as something that is a pathway, a legal pathway to permanent residence. It exists co-equally with consular processing as a different method of getting your green card. And basically the only difference is consular processing happens outside the country, adjustment of status happens inside the country. It's also important to note that the words administrative grace also have historical application in the USCIS policy memo. And unlike the way that it's framed in this memo, administrative grace is specifically defined as worthy of favorable exercise of consideration. So even the policy memo says that administrative grace should be exercised in adjustment of status. So what happened? Well, like many things that we've seen, this was issued as a surprise on the weekend, right before a long holiday. And I think the messaging is as important as the substance of this memo, because regardless of what happens with this memo, and we've already seen the administration walking this back in media, it's clear that they are taking a pause and sort of walking this back. But regardless of what's happening with the memo, the framing of the memo is important because it sends a message to adjudicators to exercise discretion in a particular way. And the concern is that adjudicators will take that signal as an authority to exercise discretion negatively. And that's really the concern here. Officers have always had discretion on adjustment of status prior to this memo and after this memo. The concern is that this memo frames their exercise of discretion in a particular way that could cause harm to a lot of individuals who are going through this process. So what does it mean? Who might be affected by the memo? Well, let's start with who might not be affected. First, remember that adjustment of status, the memo specifically references Section 245 of the statute. So in terms of scope of the statute, we believe that it should be limited only to those who are adjusting under Section 245 of the statute. That's important because asylees and refugees adjust their status under a completely different provision of the statute, Section 209. So it is our position that asylees and refugees should not be impacted by this memo. And we can talk about that in a minute, why they may be, but it's our position that they should not be under the four corners of the memo. Secondly, special immigrant juveniles. They cannot consular process, and the memo specifically says that it doesn't apply to individuals who are legally not eligible to consular process. So special immigrant juveniles should not be impacted. Also, there are certain types of individuals who adjust status that are not discretionary. NACARA, refugees, as we mentioned before, the Haitians under the Haitian Relief Act, and legalization. And then finally, people who are adjusting their status in immigration court should also not be impacted by this memo because the memo specifically applies to determinations by USCIS, not by the immigration court. But for everyone else, the memo seems to apply. And so what it says is that you should be prepared to establish that adjustment of status should be granted in the exercise of discretion. And so, the questions that have been asked on this memo are, why did you apply for adjustment of status instead of consular processing? Are there any factors that prevent you from consular processing? Why did you not leave after your authorized period of stay? And do you have any family still living there in your home country? That's sometimes asked as well. So that's kind of how the memo is framed. I'm not going to go into how you can exercise discretion. I think that's too much in the weeds for what we're trying to talk about today. But what I do want to talk about today is just the legality of the memo itself and how we think it is going to be changed in court. The first part of the memo is that you have to take the memo in the context of the statute in general, the adjustment of status statute in general. And there are four provisions of the statute that I want to point out that indicate Congress's intent to broaden adjustment of status, not narrow the scope of adjustment of status. First, 245C. Basically, in order to adjust your status in the country, you have to have a perfect immigration history. You have to have entered legally, not violated your status, not worked without authorization. It only applies to people who have a perfect immigration history. But there's a big exception for immediate relatives at Section 245C of the statute. They are forgiven for everything except unlawful entry under 245C of the statute. So if Congress wanted to narrow the scope of statute, why would they put forth 245C that forgives you for a lot of status-related violations as it applies to immediate relatives? 245K is similar. It provides for up to 180 days being out of status for employment-based immigrants prior to the filing of an adjustment of status. So again, a provision that forgives you for periods of unauthorized employment or being out of status. 245I is a provision that allows you to pay a $1,000 penalty and be forgiven for entering the country unlawfully. Again, a broadening of the scope. And then there are other things like AC-21 that allows people who are in the green card backlog to extend their H-1B indefinitely while they're waiting for the backlog. All of these are indications that adjustment of status is legitimate, that it's part of the statute, and that it's meant to be interpreted very broadly by the agency. It's also inconsistent with their own internal guidance. Chapter 1 of the USCIS policy memo specifically talks about how, in the absence of negative factors, adjustment of status should be granted. And it says the same thing in Chapter 10 of their own policy memo. It's also inconsistent with Board of Immigration Appeals precedent in cases like matter of Arai, matter of Ibrahim, and matter of Cavazos that again say in the absence of negative factors, adjustment of status should be granted. It's also rulemaking because we have this completely new standard of extraordinary circumstances as the exercise of the discretionary standard, which doesn't appear anywhere in the statute. It's a new standard that the adjudicators are supposed to employ. And one of the positive factors in the case is hardship. So it actually takes standards from waivers and imports it into the adjustment of status. So they're making you make a hardship determination for something that's never been required before. And so that because it goes beyond the scope of the statute is what we call an ultra vires action. In other words, it's beyond the scope of what Congress intended. And then finally, we could make some procedural due process claims. For example, is this going to be retroactive to cases that were filed before the implementation of the law? Where is there going to be any guidance to the public or the field about how extraordinary circumstances waivers are going to be adjudicated or what factors will be considered? In the absence of clear guidance, there's definitely going to be some procedural due process claims that we can make. Now, the big struggle with this type of litigation is a Supreme Court case called Patel v. Garland. And in Patel v. Garland, the Supreme Court said that adjustment of status is ultimately a discretionary application, and so it's shielded from judicial review. But again, that applies to an individualized exercise of discretion, not a blanket exercise of discretion. And there's very good case law from both the Supreme Court and the First Circuit that basically say when the government employs a new rule and acts like it's just an exercise of discretion, that is not shielded from judicial review. So we feel pretty good about the case law challenges on this. AILA does have a call for plaintiffs and examples out right now, and so litigation is being planned, and I anticipate that that litigation will be filed quite soon. In terms of the types of plaintiffs that we think are particularly ripe for litigation are children who will be subject to aging out, turning 21 if they have to leave the country, K-1s who enter the country for the specific purpose of adjustment of status, immediate relatives, national non-immigrant visa cases that have non-immigrant intent, TPS, humanitarian adjustments, and then those subject to the 75 country ban if they leave the country. They're also what we think would be very good plaintiffs.
Given that you said that AILA is looking for plaintiffs, we've got about 6 million readers and viewers out here. How can they participate in your lawsuit?
They can email me directly, and I can put them in touch with the company, the organizations that are doing the litigation for sure.
So I'm not asking you to speak for the administration, but could you comment on what you believed to be the thought process behind issuing this memo? Is the intent to make it more difficult for immigrants to remain and possibly self-deport as a result?
Yeah, I mean, I think it's a lot of things. I think that when this administration was elected, they were elected on a mandate, and that mandate was to close down illegal immigration, right? And their focus was really at the border, and they've done that. They've done that very effectively, very rapidly, very quickly, and we quickly saw that turn to interior enforcement. The fact is that the numbers of arrests that this agency is supposed to make, the only way that you get to that number is not by going after criminal undocumented immigrants. It's only by going after legal immigrants. That's the only way that you get to the arrest numbers. And so we think that this is yet another part of the effort of this administration to, put cogs in the way of legal immigration. It also intentionally pushes cases to the consulate. Why? Because if you push cases to the consulate, they can be put in what's called administrative review, which means they basically go into limbo and investigation indefinitely as long as the government wants it to. And there's really not effective ways to challenge that. And if ultimately the case is denied, there's no judicial review over consular denial. So there's a lot of power that the government gets by pushing people outside the country and pushing cases to the consulate.
Yes, Nestor Fantini, Hispanic LA. And my question is, what concrete steps can sanctuary cities such as LA, as a matter of fact, take to assist and protect the people who may be affected by this policy?
Yeah, great question. Let me start by saying I don't think it's limited to sanctuary cities. I think this memo applies across the country, regardless of what jurisdiction you're in, and everyone is going to be impacted by it. So I think this advice would go equally to individuals living in non-sanctuary cities. But the first thing is, realize that like other things that this administration does, it comes with a lot of rhetoric and bluster. And, people ask me, what am I going to do with my cases? And the answer is absolutely nothing different. And here's why. Because I believe that this is unlawful. I believe it's contrary to the statute. So yes, I will submit evidence of discretion in cases that are necessary, but I fully intend on taking these cases to court if they're denied because it's unlawful. And I think that, so for me, it is full steam ahead like we've always done it. Because this government can't change the law through memo and footnote. They can't do that. And if they try to do that, the only way to challenge it is in federal court. So that's what we would plan to do.
Yeah, and just to clarify that, this memo completely bypassed the proper rulemaking process, which would have a 30 to 60-day public comment period, correct? Is that one basis on which you hope to challenge this memo?
Correct. Yes. To the extent that this changes the way that the public has to interact with the agency or creates new conduct, it's by necessity a rule and should have gone through what we call notice and comment, which would have allowed for democratic participation in the process, right? Stakeholders like sanctuary cities, stakeholders like individuals who represent special immigrant juveniles would be able to comment and explain why their population would be impacted. The agency didn't do that. And so that definitely will be one of the challenges that would be raised.
Is this memo already in effect, which is mean that it applied to those who are applying right now for a green card?
Yeah, great question. By all indications, the memo itself doesn't indicate an effective date, but because we have seen it implemented at interviews, even the day before the memo came out, we know that the memo is effective immediately, and it's being implemented immediately.
So the question is, what does the administration suggest for applicants who cannot apply for status in their home countries due to various reasons? For example, U.S. Embassy doesn't work there.
The memo specifically says that individuals who can't consular process are not subject to the memo, but they don't really explain what that means, right? So your example is a good one. If there's no consular relations in that country, theoretically, you could argue consular processing doesn't apply. What's not clear is, individuals who may be subject to the 3 and 10-year bar if they leave the country, right? If you have unlawful presence in this country and you leave, that departure triggers a 10-year bar, which makes you ineligible to reenter and therefore ineligible to consular process. So, those kind of questions, the scope of this memo and the lack of guidance over those very good questions are exactly why this will be challenged on lack of procedural due process.
The president seems to already be rolling back this action. We've seen some reports of that. Predict the memo's future. Will it hold, in fact?
Yeah, I think legitimately there was a lot of blowback on this memo, largely from the employment community because of the concern over, what seems to be an elimination of what we call dual intent. So there are two types of non-immigrant statuses. There's non-immigrant status and then there's dual intent status. And most non-immigrant statuses are non-immigrant intent, meaning you can't have the intention to get a green card while you're on that status. There are a couple that are dual intent. H's and L's are dual intent. So the problem is when you file an adjustment of status application, it's always been considered a period of stay authorized by the Attorney General, right? And that's a sort of term of art that has entered into the lexicon of immigration law. But this memo seems to do away with period of stay authorized by the Attorney General because it specifically says maintenance of status is one of those factors that they're looking at in terms of the exercise of discretion. So people like students, tourists who overstay because they've applied for adjustment of status now appear to be more vulnerable under this memo. But even H's and L's under the plain terms of the memo don't seem to be excused because under the footnote it says, dual intent is also not necessarily an exercise, a reason to exercise discretion in a different way. So because of those concerns, I think the business community reacted very swiftly, and we've seen the government now back off and say, no, if you have an economic benefit, you're not implicated. So yet to be determined, I guess. And I want to hear more from, I think we have some colleagues that are going to talk more specifically about the employment-based stuff.
One of the areas that has been flagged already for a number of our clients is around people who have come, especially on the family side, and marriage cases, which historically has been an untouched area Right, like the historic guidance to State Department officials and CIS officers is like, look, it is not our job or your job to judge what what true love is, right? It can't be fraud. It needs to have the set of evidence that shows that it's a legitimate relationship. But you know, it is not the U.S. government's position to really like scrutinize, and judge what is love. And so marriage cases have generally been relatively adjudicated pretty quickly and successfully in the past. And so the cases that are coming up now that are catching people in this like limbo world or have been moved to, actual immigration court that we've seen have been folks where they have come in on a tourist, let's say a tourist visa, or a student visa, and then they've overstayed that visa. So they have legal entry, like they were, and then they come in, and then they get married to a U.S. citizen, and then they file for adjustment of status. And historically, there's been this concept of a 90-day rule where like the government understands that people's life changes and people's plans change. And so if you file one, say you come in at the border and you say, hey, I'm here to visit my friend. And then within 90 days, you get married and file like a green card application, adjustment of status application. The government's like, you probably already knew you were going to do that when you came in. And that would be judged negatively. Now, but then if you waited more than 3 months, the government's generally saying, like, again, who are we to judge how quickly someone can fall in love? And now what is happening is that those cases are getting increased scrutiny. So like I think if you had to step back, I'm not in the minds of the administration, but say, hey, like what they're getting a lot of pushback from the business community saying, hey, this is actually making it much harder for us to keep or to understand how to move forward with folks that are quote unquote generating positive economic value. On the other hand, like they have been increasing cases already of people on the like, I'm not sure you that you were fully truthful when you came in on a temporary non-immigrant visa, such as a tourist visa, and now you're filing for adjustment of status with your spouse, and you really should do this in your home country and do it through the consular process. And so those have been the cases that have been, much clearly shown that the current post-memo adjudication process is changing.
Let's welcome Julia Gellert of the Migration Policy Institute, who will discuss the impact to other immigrant communities and who will not be affected by this new policy. Welcome, Julia.
And Zhao's intervention on family is perfect because I was going to focus particularly on the effects on family members. And Jeff has already covered some of the groups that should be most excluded from this policy. Refugees and asylees should not be affected by this memo. He also mentioned that there are some other humanitarian categories who shouldn't be affected. But many people adjusting through our family-based immigration system could be affected. Every year, hundreds of thousands of people get green cards through a spouse or a parent or a child who is a US citizen. And this memo is casting doubt on whether this adjustment of status at this high level through family relationships to US citizens can continue. So people who adjust status through a US citizen spouse is the most common, but also adult child, come to the US and stay in the US in different kinds of ways. So some people come on a temporary visa. We've already talked about some of those today. There's the fiancé visa. The whole purpose of that temporary visa is to come to the United States and get married. And then apply for a green card through the spouse. There are, of course, a lot of temporary work and student visas, such as the H-1B visa, the F-1 student visa. People come on those visas, and after a few days, a few weeks, a few months, or a few years, or several years in the United States, they might fall in love with a US citizen and get married and seek to get a green card through that spouse. And then still other people come to the United States on a temporary visa, could be a tourist visa or a work visa, or they come with something called humanitarian parole. And then their status ends, but they stay in the US anyway. And they fall in love with a US citizen, they get married. It used to be that as long as their initial entry to the United States was legal, they could get a green card through their US citizen spouse, even though they're out of status. Under the new memo, as we heard, immigration officers are encouraged to use their discretion to reconsider whether these folks should be able to get a green card inside the US versus going abroad. I think, as we've discussed, some of the people who are more likely to be okay and still be able to adjust are those who have a valid status on a temporary visa that allows you to wish to stay in the US permanently. So the fiancé visa should be one of those visas. The H-1B visa is one of those visas. People who might be in a tougher situation under the memo is people who come on a temporary visa that requires that intention to return back home. So a student visa is one of those. Even if you come to the US and like me, you spend many years getting your PhD, you start to feel like you belong in the United States, you have told the government, I plan to go home at the end of my period of stay as a student. That's my intention. If somewhere in your many years in the US, you fall in love and marry a US citizen and get sponsored for a green card, now the government might be saying, well, you told us you were going to go home, so maybe you should go home and get your green card abroad. And then the people who I think are in the most difficult situation are people who are now living in the United States without status. They entered legally, but now they don't have status. They're very likely under this memo, as it stands, to be told to return home for consular processing rather than getting a green card inside the US. So is consular processing so bad? For some people, it might be a small inconvenience. At the very least, they have to pay for some expensive international travel. If they don't have family or friends abroad, they might have to pay for a hotel or Airbnb. They might need to take a short leave of absence from their job. But if there are delays, if people get put into additional processing steps, they could get stuck outside of the US for months. This can get very expensive. It could put their job at risk, and it could mean long periods of family separation from their loved ones in the US. I think another thing to keep in mind is that this memo is envisaging shifting a lot of work from US Citizenship and Immigration Services inside the US to consulates outside the US who don't have a plan to staff up for this additional workload. So we should expect that if it goes forward as written, that could lead to longer and longer delays to get appointments for those interviews at the consulates. Another challenge is that when you get a green card, when you apply for a green card inside the US, if the government tells you no, you have more rights inside the US to challenge that negative decision. If you're outside the United States, there's this idea of consular non-reviewability. It's much harder to challenge a denial of a visa than it is to challenge a denial of something inside the US. Jeff already mentioned that some people are further affected by the fact that right now we have both a travel ban in place for 39 countries that cannot get immigrant or permanent visas to the US. And we also have an immigrant visa pause. It's a pause without any end in sight for 75 countries. When you add those together, there's some overlap. So it's 91 countries. People from those countries cannot get a green card or cannot get a permanent visa to come to the US for a green card from those 91 countries. And that includes some major sending countries: Iran, Cuba, Venezuela, Afghanistan, Pakistan, Colombia, countries all over the world. And then I think Jeff already mentioned that people who have spent at least a year in the US without status also face a 10-year bar to re-entry. So there are a lot of people from these 91 countries, people who have a year of unlawful presence in the US, if they're told to go get a green card outside of the United States or to apply for an immigrant visa outside the United States, they're being told, actually, you can't get permanent residence here, period. I think what this means, and it's encouraging to hear lawyers say that they're proceeding forward and will challenge this, but I do think that this suggests that for people who have already applied for a green card inside the US or who are thinking about it, that getting legal representation or legal consultation is more important than ever before. And this is particularly true for people who don't have status in the United States. The calculus of whether now is the time to apply for a green card may be a little bit different than it was before the memo was issued, and people should proceed with real caution about whether this is the right time. As Jeff said, there's probably litigation coming, so we can all follow the news on whether that puts the memo on pause. And I wanted to end by just pointing out that this memo is coming on top of a lot of other moves by the Trump administration that are making it harder for people to come to the United States legally or to maintain legal status inside the United States. This administration doesn't see much value in legal immigration, even of high-skilled workers sometimes. And this policy memo is just one piece of a wall that the administration is trying to erect to make it harder for immigrants to come and for immigrants to stay. And I think the confusion around the memo is typical of what we've seen, and I don't know that everyone in the administration really minds. I think they might be glad if this is the last straw for some people to decide whether they really want to stay in the US or if they can really make their lives here, because they would like to see lower legal immigration. But that said, a lot of our immigration system is functioning just like it always did. There are many, many people who are not in any way affected by this. So it's really important for people to really dig deep and understand how this policy does or does not affect their particular situation. And their path may be as clear as it ever was to come or stay in the US.
Have we already seen a diminishment of immigration flows into the country as a result of policies rolled out over the last 18 months? And do you expect that trend, if it's there, to continue given this new memo?
The public data on this is pretty backlogged. I know that some folks have some private data that they can see that I haven't had access to, but the government data through September of last year already showed a decrease in issuances of visas for people trying to come legally from abroad. And that happened both through permanent immigration and through temporary immigration. I suspect that when we get more months of data, we'll see a further decrease. And I do think that we'll continue to see that decrease until or unless the courts strike down some of these travel bans and other changes. But even if those policies are struck down, the government is just moving very slowly on immigration applications, even the ones that it is processing. It can gum up the system on its own in a lot of ways. There's also, is our economy as strong as it was before? Do people kind of just feel like maybe the US isn't the place they want to go right now? So there's a lot of factors outside of policy that shape immigration levels too.
Will applicants have to remain in the home country until they have that green card in hand? Or can they return to the US once they've applied abroad?
It depends on their other kind of status that they have. I should let the lawyers maybe answer this question because they probably had clients go through this and I haven't. But if somebody has some other kind of status and valid visa stamp that would let them live and work in the United States, maybe they could come back. I'm not sure. But for many, many people, they would have to wait abroad until that visa was issued. But Jeff, do you want to add onto that?
Yeah, sure. I think the problem with entering the country when you're waiting abroad for an immigrant visa is that you're waiting abroad for an immigrant visa, which means you have immigrant intent. And so it's impossible to come in as a tourist or a student because in order to do that, you have to demonstrate non-immigrant intent. And so, most consulates just won't allow you to enter. Most port of entries would turn you around because you necessarily can't demonstrate non-immigrant intent.
Right. But if you had an H-1B with a stamp, you could, in that case, you could, right?
Yeah. So H's and L's are those dual intent categories that allow you to enter the country while you're consular processing. So if you're in those two categories, you should be able to enter without a problem.
And Shao, I just wanted you to weigh in on this. Is it possible that people could get stuck in that 8-decade-long green card queue while they're waiting for their approved green cards applications to actually result in a green card because of per country caps?
So if we're to separate these two worlds out, the per country cap will there's no plans right now, and there hasn't been any indication from Congress to change the per country cap. And so that wait time that varies by country, especially for India and China, and Mexico and some other, will continue to persist. I think the concern here is where is this person going to be? And in some jobs they may be able to work remotely, and in this world when they but for most cases, the long-term, and I'll talk about this in a second, the long-term expectation from when they came to the country to begin with as international students through their F1 process, through OPT, through H-1B has been multiple decades of precedents around like, okay, that is the pathway to legally study, stay, and work, and eventually become a permanent resident in this country. And to the earlier question, from an anecdotal standpoint, we have seen a meaningful decrease in in previous years employers filing H-1Bs in the visa this year. I mean, I'm sure Jeff can share his firm's data too, but like, yeah, we've seen like year over year, the rates have gone down, and then especially it hits, especially with the $100,000 fee, it has really hit a lot of rural health centers in particular, who are really counting on the ability of bringing over foreign doctors and healthcare professionals to fill a critical shortage in communities that desperately need that talent, and cannot afford the $100,000 now to bring that over. So and there's a bipartisan bill to try to carve those out of the $100,000 fee, but that has not passed yet. And so a lot of communities around around the country, especially a lot of those serving minority heavy areas, are going to be continuously short in their healthcare professionals availability because of these rules.
Julia, let's go back to questions for you.
My name is Pamela from the Immigrant magazine. And I know we talked about students, but I'm still a little confused in the student category, because a lot of times some students come, they spend years and sometimes decades going to school. And just like any other category, might fall in love or have opportunities come to them. And some of them while they're in school, that's when they're also trying to do that adjustment, maybe get married, have a great opportunity and stuff like that. How would this work in their case? Would they have to abandon school and go back to their country of origin to have it change the status, or how would that work? The student category is really confusing for me.
Yeah, what the memo says is that because the student visa is a visa that requires you to say you plan to go home at the end, that I think it's sort of suggesting that government immigration adjudicators should perhaps send you back to your home country to apply for your immigrant visa in your home country instead of in the United States. As Jeff was saying, that is different than how things have been operating, and that will, be a point of litigation. Things change in life, and our immigration system has recognized that people's plans do change over time, and maybe they honestly intended when they got that student visa to go back home, but now things have changed. So we will have to see how this plays out, but on its face, the memo seems to be suggesting that somebody on a student visa might be asked to go home to apply for that immigrant visa.
You can see sort of a theme woven through this, is that there's a presumption that when you applied for that student visa or that tourist visa, that you committed misrepresentation or that you committed fraud, right? That there's this presumption that now you're coming into this green card. Why didn't you go back home? Or, and I want to be clear that there's a difference between fraud and, your intentions changing once you get here. And so, part of the reason that I think it's really important what Julia said about getting an attorney is if they allege fraud or misrepresentation and that goes into your record, it can derail your immigration case forever. And so it's really important that you are able to have somebody effective, an advocate that can fight back against any allegation that this non-immigrant intent issue necessarily involves fraud.
I originally wanted to know, and I think you might have answered it, Julia, the circumstances under which someone who applies for a green card has to go home and then wait 10 years before they can be considered. And the follow-up is, at what point can memos and executive orders be put on hold when they're challenged?
Yeah, great question. So if litigation, I'll answer the second question and you can answer the first question, Julie. On the litigation piece of it, what happens with litigation is they take forever, right? A lawsuit can take a couple of years to resolve, and there's harm that happens in the meantime. So what happens when you file a lawsuit is you file a lawsuit and you will often file it with what we call a temporary restraining order or a preliminary injunction, asking the court to intervene immediately on an issue because there's immediate harm happening. So if this policy got challenged, I anticipate that would also be challenged with the temporary restraining order, asking the court to immediately enjoin the implementation of the memo while the court considers the legal issues involved. And we've seen that happen. You know, there was a case that came out today called Dorcas out of the court in Rhode Island that struck down the USCIS adjudication pauses and issued an injunction on those. The problem is that when a court issues an injunction, it issues it at the district court level, which is the lowest level of federal court. And the government can immediately appeal that to the circuit court and ask for a stay of the injunction. And that we've seen that happen, right? Where the district court will issue this memo to be enjoined, and then the government comes in and appeals that decision up to the circuit court, and the circuit court stays the injunction. So it becomes this like chess game of when a case is enjoined or not, and you really just kind of have to monitor what's happening in the litigation.
On the 10-year bar, so based on laws in 1996, if you spend at least 180 days but less than 1 year in the US without status, you face a 3-year bar to re-entry to the United States. That bar gets triggered if you ever leave the country. And then if you spend a year or more in the United States without legal status as an adult, that's when you face that 10-year bar, which again kicks in if you ever leave the country. So that's why if people are told they have to go get an immigrant visa at a consulate abroad, they would trigger that 3-year bar. In most cases, it's a 10-year bar to be able to come legally back to the United States. And that is a very long time to ask people to be separated from their families in the US.
We will go on to our final speaker today, Xiao Wang of Boundless Immigration. Xiao will discuss what's at stake for those on employment-based visas, such as H-1Bs, as well as their dependents, children, and spouses. Welcome, Xiao.
Oh, glad to be here. Thanks, Sunita. I think we actually covered a lot of what I was going to say. So, but ultimately, the reinforcing the point is like for multiple recent decades, right? Applying for a green card from within the United States has been the standard path of people legally, studying, working, and staying in the U.S. Right? So that more than half of all green cards issued have been through this adjustment of status process, which means that it's not what you would call extraordinary. And as Jeff highlighted, that there's a lot of legal challenges that are going and redressing this unilateral reframing by USCIS on a Friday night memo before a long weekend, no rulemaking, no public comment period, no congressional action. The actual memo itself, if you look at the language from an employer or an employee perspective, is that this, the definition of extraordinary relief doesn't appear in the regulations, and it's not in the policy memo. And that what that means is that as people are thinking about coming here, we talked about these dual intent categories, right? That the workers can be legally in the United States temporarily, such as H-1B, while also pursuing permanent residence. That was always the expectation of these categories, and these are engineers, nurses, researchers, product leaders, physicians, teams. And in footnote 20 in the memo, it says that maintaining lawful status in the dual intent non-immigrant category is not sufficient on its own to warrant a favorable exercise of discretion. So all this does means is that, but it adds a layer of confusion to everyone, because it doesn't say, well, what is sufficient on its own? And before, for decades now, the expectation is that if you are legally here and working and have no criminal history and other negative facts, that this would be the default yes path. And so now the question becomes, what if you had a gap in employment? What if is that a problem? What does showing economic benefit mean? And so this all adds a layer of uncertainty that will have both short-term impacts on individuals and their families, which I'll touch on, but also long-term impacts in American competitiveness and the attractiveness of starting this potentially years or decades-long journey to come and stay and work and legally create your life in the United States. So yeah, the counterpoint for this is that, well, yes, you can always just apply from abroad through consular process, but that's not a practical answer for the majority of folks. And not only mention the 75 country bans and these pieces, but also that like you're basically in many cases forced to change the way that you do employment. Right? So the way that consulates is going to be many months to potentially years. And that means either upending your life as an individual and waiting it out, or upending the lives of your family to be able to wait this process out. And so that means leaving the United States, these workers, with no clear timeline for return. Right? Their employer waits, their kids wait, their mortgage doesn't wait, and they may or may not have income coming in, or it may be different because they're now in a different cost of living environment. And then for the U.S. companies, and why we're seeing a lot of questions from our corporate customers and clients, and potentially decrease in total number of applications, is that this adds an additional wrinkle to their level of investment in these employees, that they've hired them, they've trained them, they've sponsored all of their previous applications, whether from H-1Bs and extensions and through the perm process, and they've invested already years and thousands of dollars per case, and now it's unclear what the future is going to be and how it applies to their operating plans, and they risk losing senior people, especially as they've now been here sometimes 3, 6, or longer number of years, and that the entire sort of corporate planning cycle for human capital has been upended, overnight, and needs to change. And then the final piece I talk about is the family, because people on employment-based visas, especially those who've been here for a significant amount of time or come in later at life or have higher incomes, like the types of immigrants that this administration has repeatedly said they want to continue encouraging to come to the U.S., are also more likely to have families, spouses, children, that they have their own careers and derivative work authorizations that are now thrown into limbo. And then their children have been able to grow up in U.S. schools, with friends and futures that they understood to be American, and they could stay in America, and they've never actually knew life in another country. And so this adjustment to status process historically has been, clear to like keep these family units, productive and stable in the United States. Right, that including keeping them eligible through multiple ages and through the whole multi-year long backlog or waiting process. And so these protections only work if this idea of a pending status for adjustment of status still exists. And so if applicants are now pushed abroad and timelines, these protections start falling apart, and spouses will lose work authorization. Children might have to age out and have to reapply on their own from scratch, potentially in a country they've never experienced or lived in before. So ultimately, companies, individuals, students, immigrants have built an entire life of a multi-decade plan around a process. And there's been a clear set of expectations of what needs to happen for them to legally continue on this process. Right? International students come on F1, have opportunity to transition to OPT, goes to the H-1B, potentially renews H-1B, goes through the perm process, and then through adjustment status and permanent residence. So that the economic, the job creators, the high skilled employees, the taxpayers, the positive economic inflows into this country, which has a declining birth rate and whose hopes on continued GDP growth comes from immigration, has been on this tried and true path. And so changing these rules midstream with no warning and no time to adjust will, create a increasing, level of not only confusion on the immigrants that are here, but a dissuasion for anyone who's thinking about starting on this journey. So if I think universally, if you talk to immigration practitioners, we'll all agree that the system should be reformed. especially on the work side, right? Like the H-1B program was created in 1990, right? And it's like the countries and the needs of this country has changed meaningfully over the last 30 years. And those should be adjusted, and that is explicitly written in as what is responsibility of Congress. And we should all push for Congress to modernize the immigration process to make it adapt to what the country needs today. But that change, there's a process to it, right? And that process is not a opaque, slightly confusing, maybe trial balloon test memo that comes out before Memorial Day weekend, and then hope to continue adjust depending on what kind of backlash they receive in return.
Zhao, H-1Bs are allowed to start up businesses with understandably multiple constraints. Do we stand to lose that innovation that so fuels places like the Silicon Valley in Austin, Texas?
I mean, 50% of Fortune 500 companies are run by immigrants or started by immigrants or descendants of immigrants, right? Like the whole concept of American, leadership in the technology space is driven by immigrants. And now we're in this race for AI dominance, especially across America and China. And so you can make a very compelling case that the future for American security is going to rely on like the flow of immigrants building, the models and the AI tooling in the US as opposed to in China. So it's not just like entrepreneurs, of which is a meaningful part, but if you think of all of the various temporary visa categories that allow people to stay and work in this country, not only H-1Bs, but O-1s, TNs, E3 folks on Australia, folks from Canada, folks from Mexico, like there was always previously an expectation that if you create something, if you have gainful employment, or create a successful company, or other means like have put your roots down in the U.S. and you do it legally, and you don't commit any felonies, and otherwise live a productive, healthy, and contributory, I can't even pronounce that word, life in this country, that you will be able to continue to stay in this country. And that has been changed for the first time.
Thank you. Julia, Aitana Vargas had a question for you, and she asked me to ask it. Any data on which countries are experiencing the largest decrease in U.S. citizenship applications as a result of Trump's immigration crackdown?
That's a great question, and I don't have those numbers in my head, but they are available from government websites, so we could look at that. I mean, I think in terms of citizenship, that's a little bit of a different question than who's able to come to the United States. I do think we would see a big decrease in the people who have been coming to the border, but then through the legal immigration system. Actually, I don't know the answer. That's a good question.
Mr. Wang, you kind of answered my question a little bit, but my original question was, if this memo becomes a rule, how would it affect businesses that have green card holders and seekers? But my other question is now also, how has the blowback from businesses with the administration been regarding this memo?
So the first one is, hope you understand, it's like it creates it's a chilling effect, right, on people wanting to come to the country, stay in this country, work in this country, and corporations being willing to hire and invest in all the fees, the legal work, but also the training for immigrants. I think from a policy angle, what we've noticed is an interesting switch between the first Trump administration and the second Trump administration, right? So the first Trump administration would say a lot of things, and then would pass, again, like this is, the Friday night memo before long weekends is a tradition that goes back to 2018 or earlier, right? So to the point where there was periods of time where different applications for immigration at different states would have to have different forms attached to it, which is bonkers when you think about this from a national policy perspective. But what in the first Trump administration, they would propose things that weren't fully thought out. would get challenged quickly in court. There'd be nationwide injunctions or other things that would and pull back. And we saw this with some of the fee charge changes. We saw this some with the public charge rule. Like the administration would not be able to. It would not. It would be a lot of posturing, but there wouldn't be a lot of substance. This administration is different. They have, in each case, all the way down from state and USCIS down to adjudicators, there's an expectation when this administration says they're going to do something, they're actually going to follow through with it, and they're going to take the necessary steps to make, the core part of what they're trying to do stick. On the other hand, what we've seen in this administration is that they actually are almost treating this as a marketing experiment, in the sense that they will put something out there and then see what the market says. And there are numerous constituents that have the ear of, Howard Lutnick, of the president, of Stephen Miller, of different factions within the cabinet, and then they would adjust based off of what the market has said. And so in this particular case, the idea was they put something vague and sort of kind of over the top in the initial memo, and now they're collecting data, like who is like pushing back, where are the areas they think that they will lose support from their base, where are the areas that like will be continue this to be aligned with what their base is looking for, as well as what the policy is looking for. And so in this world, like Jeff mentioned, I suspect that they're going to be a lot more generous on releasing this extraordinary clause and like judgment for AOS for H-1Bs and for other employment-based categories, given the amount of pushback that they've seen. But this is, it's almost in a different frame of mind. It's like we actually have more of an opportunity. We collectively, as a community, society, and the community and practice, have a far more ability to influence this administration where it actually lands, because they may not even know at this moment where they want it to land.
I'm with Amerikai Népszava, of a Hungarian newspaper. And my question is, could the memo create significant labor shortages in certain industries and economic sectors? And how can employers and small businesses best prepare for this shift?
I think it depends on where the memo ends up defining. All right, so right now, just similar to Jeff, like our advice for all of our clients is just proceed as usual, right? You can add some more like positive factors, but like there's a line, get in line, continue to operate as usual until we get more clarity, and USCIS officers actually get more clarity. Although there's definitely more time spent on preparing folks for their interview, adding more sort of interview questions that they should be expecting. But if the question is, then it's like, if it actually goes into effect. Right, like we're saying that for a lot of employment-based categories, you actually have to upend, disrupt your life, move out of the country, wait for a consular process before coming back to the country with yourself and your family. That would be like wildly disruptive across all of the industries that are currently dependent on, especially these dual intent immigrant visas categories. So think healthcare, think technology, think there's and organizations are going to need to really think about where and when they're actually going to sponsor immigrants, and for how long those immigrants are going to likely stay, right? If they don't have an ability to feel secure in their future in the country. So my hope is that all the lawsuits that Jeff and others and in different coalitions, will put enough compelling reasoning for like this to be clearly defined. So I think, ultimately, like what people need is clarity. And so then the moment that it's actually have clarity, then people can decide how they want to live and choose their life or their hiring practices.
So let me ask the question. Sandra is from Peninsula 360 Press. What is the most important thing immigrants and their families need to know about this policy and its potential consequences? Julia, let's go to you first.
I think I would just say that we don't know the end of this story yet. We don't know how this will be implemented, and we don't know how the litigation will fare. So people should stay prepared. But, as we've heard from the others, think about proceeding with their case, but with legal counsel. But just, know that the shape of it is yet to be determined and how it's carried out and how the litigation continues.
Thank you, Julia. Xiao?
I think Julia nailed it. I would say that like for beyond sort of keeping track and like seeing and waiting how this turns out, I do think that like for those who have green card interviews coming up for adjustment of status, should be prepared for a set of additional questions defending why they're applying for adjustment of status, and to understand that there's extra scrutiny placed upon those answers and those whys.
Jeff, final word.
Sure. I would have a message for the reporters and then a separate message for the public. The message for the public is just to highlight what Julia said, and that is like, go see a lawyer. In these times with this administration, I think going to a lawyer annually should be like the same as like a medical checkup, right? Like if you're concerned about your status, have an annual checkup with your lawyer just to see where you are in your immigration lifestyle cycle and make sure that you're not vulnerable. For the reporters, the message is actually more important and I think more critical, and that is it is up to you all, and we have seen it be effective, to tear down the narrative that this administration is putting out to the public, the panic and the fear and the unnecessary sort of inflation of these issues. And it's important that you all deflate that adjustment of status is not extraordinary. In fact, it's quite ordinary, and it's been something that's done for decades, and it's something that Congress intended. So get rid of this idea that you're doing something unusual or extraordinary by following the law as Congress intended it. Get rid of this idea that you're somehow violating the law if you overstay a visa and apply for adjustment of status, because the fact is that's the way it's always been done. So the message for the media is really kind of tear down the narrative that this administration is intentionally putting out to cause panic and fear. And you're doing a great job of that. So thank you.